The Court of Justice of the European Union has ruled that Poland cannot refuse to recognise same-sex marriages concluded abroad. The case is the result of a legal battle brought by a same-sex couple who formalised their relationship in Germany, in accordance with the law in force there, and then wanted it to be recognised in Poland, even though this is contrary to the law in force in the Polish constitution. The Court of Justice of the European Union has ruled, and the left is celebrating. History is being made. The CJEU has just issued a ruling stating that Poland must recognise same-sex marriages concluded abroad. The CJEU ruling is highly controversial because the European Union wants to impose a law that is not in force in Poland. This ruling is not a neutral interpretation of the law, but a mechanism of pressure and coercion by the CJEU on member states. The whole case began when two Polish citizens who formalised their same-sex relationship in Germany and wanted it to be recognised in Poland, even though this is against the law. The registry office did not give its consent and the men took legal action. There exists no institution of same-sex marriage in Polish law, and the transcription of such a foreign marriage would be completely contrary to the law. The Constitution may be invoked here, and the authorities are probably right to do so. Until these provisions are changed, no relationship between two people of the same sex can legally be called a marriage. The Polish Constitution is crystal clear. Article 18. Marriage is a union between a woman and a man. Family, motherhood, and parenthood are under the protection and care of the Republic of Poland. The men's case was referred to the Supreme Administrative Court, which, before issuing a ruling, sent a preliminary question on the matter to the Court of Justice of the European Union. Why did the Supreme Administrative Court take this course of action? This is a consequence of the destruction of the constitutional order in Poland, which manifests itself, for example, in our government's failure to recognise the judgments of the Constitutional Tribunal. The Constitution is the highest legal act, and all sources of law must be consistent with it. This is explicitly stated in Article 8 of the Constitution. Moreover, the opposition points that the CJEU does not have the competence to rule on such matters, citing the Charter of Fundamental Rights. This ruling must be treated as legally non-binding. This usurping authority has no right to issue such regulations or rulings on Polish matters. Poland and the United Kingdom have guaranteed that certain provisions will not be applied if they are not recognized by us in Poland, so same-sex marriages should not be recognized. This is contrary to the protocol attached to the Treaty of Lisbon. And this may be only the beginning. First, it is about legalizing same-sex marriages contracted outside Poland, and then it is about legalizing children born to such couples. I have no doubt about that. The question is whether Polish institutions will comply with the CJEU ruling, which directly imposes a law on us that is not in force in Poland.